of a contract. Remember, we discussed the terms of a contract. We also discussed conditions, warranties, and innominate terms. Remember, our discussions the following week were about construction of contracts. You have your contract with you. You have a dispute with the other party. You now want to go to court, and the court follows certain rules that help it to determine the dispute, to solve the dispute. Remember, the court will be following certain well predetermined rules. It is a court that is going to interpret what the parties have themselves put in the contract document. Remember, the rules, the canons of interpretation that we discussed were: one, the objective test. Remember, commercial common sense, as discussed in the case of investors' compensation scheme versus Westbrook Building Society. That is a discussion that we discussed that day. Remember the dictum of Lord Goffman. That is a discussion that we had that day. Remember, after that, we went on to discuss the factors that vitiate a contract. Our discussion was centered on those factors that impair the contract document, those contracts that lead to the contract being declared void, being declared voidable, being repudiated. And remember, we started our discussions by discussing the factor of misrepresentation. Remember the three types of misrepresentation that we discussed. We discussed innocent misrepresentation. We discussed fraudulent misrepresentation. We discussed negligent misrepresentation. Our discussion, the following week, we discussed about mistake. Mistake will lead to a contract being vitiated. If, for example, parties to the contract made a particular mistake when they were entering that contract is going to be vitiated on the basis of that mistake. And we discussed several types of mistakes. The first type of mistake is a common mistake. We also discussed mutual mistake. We discussed unilateral mistake. That was our discussion that day. Remember, the second set of vitiating factors that we discussed that day was duress and undue influence. How does duress affect the performance of a contract? Duress has to be duress to the person. Someone threatens your life. Someone threatens to injure you. It has to be duress to the person. Remember, we said that duress to goods will not lead to the contract being vitiated, because mere commercial pressure will not lead to the contract being vitiated. It has to be something giving rise to illegitimate pressure and compulsion of the will. Someone is leading you to enter the contract against your will. They are affecting, they are infringing your very free will to contract. Remember our discussions on the will theory. We proceeded to discuss undue influence. How does undue influence lead to the vitiation of a contract? We discussed that undue influence arises in situations where there is a special relationship. For example, a teacher-student relationship, a parent-child relationship. We also discussed doctor-patient relationship, so that someone has some sort of influence over the other, and therefore they misuse, they make bad use of that influence that they have, and they mislead this party who was less influenced in the contract, so that this person did not enter this contract out of their free will. They were unduly influenced. That is what we are trying to say. We proceeded, the week before we stopped our lectures, face-to-face lectures, we discussed illegality. How does illegality affect the performance of a contract? Remember our discussions to the fact that there are two sets of illegality. That is what we said. A contract can be illegal ad formation, and that contract is going to be void ab initio. If this contract is illegal in law, this contract will not be enforced, because for example, there is a law that illegalizes such kind of activities. Parties are getting into a contract, for example, for murder. Yeah? They're agreeing to murder someone, and there's some sort of consideration being paid. That kind of a contract is illegal. Yeah? It cannot be salvaged by the court. It is void ab initio. We also discussed contracts that are illegal at performance. Yeah? Contracts that are illegal as performed. Yeah? So that we have in a contract that is legal at formation, but it is being performed in a manner that is illegal. And could be, it's only one of the parties who is carrying out the illegality. The other person is not to blame, is innocent. So this innocent party can go to the court and file their claim so they can recover damages. They can recover damages from this kind of contract because they are not to blame. Yeah, they are not in pari delicto. That is what we said. So our discussion today, and I go through it very, very briefly, is on void contracts, and this is something that we have been mentioning every other day that we met in class. Void contracts. Void contracts are those contracts that are not recognizable by the law. They cannot be enforced, and that is what we said in class. Yeah, so that a contract that is void, it is like it never existed. Yeah, the law does not recognize it. That is what we said in class. Yeah, so that if a contract is void, you cannot file a claim in court for damages, for example, or for any equitable remedies that are available in the law of contract. That contract cannot be enforced. And there are several categories of contracts that are void. Contracts can be void under statute, so that there is a statute, there is an act of parliament that provides for such contracts not to be recognized as legal in nature or as enforceable. So that contracts that are void under statute, there is that particular provision in the statute that provide that such contracts will not be recognizable in law. And we can give the example of Section 8 of the Sale of Goods Act. So that Section 8 provides that if parties to a contract of sale enter a contract for the sale of goods and be known to them that those goods have perished without their knowledge, those goods have already perished. These persons have entered a contract of sale of goods. Let's say they are entering the contract of sale of oranges, sale of bananas, and unknown to them, yeah, these oranges, these bananas have already perished. Such kind of a contract is void because the subject matter of the contract has been damaged. Contracts can also be void at common law, and there are three categories to that effect. So that if you have contracts that are void at common law, you have contracts to oust the jurisdiction of the court, for example. Parties to a contract enter a contract to, and there's a clause in that contract stating that the court will not solve any dispute that will arise during the performance of this contract. You cannot exclude the court from adjudicating disputes arising from contract, because courts are the arbiters of all disputes arising from citizens. We're guided by the rule of law. You cannot exclude the court from your contract. Such kind of a contract will be declared void at common law. The other set of contracts that are void at common law are contracts prejudicial to the status of marriage. Marriage is a very sacrosanct institution. You cannot enter contracts that are prejudicial to the status of marriage. For example, two people enter a contract that is meant to break up a marriage, for example, and this contract is complete with all the elements of a contract. There is consideration, there's money exchanging hands. Yeah, such a contract that leads to breakage of marriage, such kind of contract that leads to divorce. Someone is trying to cause divorce in the institution of marriage. A contract, for example, to look for a wife for someone. I remember the time I gave an example in class that someone their friends feel that it's taking too long to marry, for example, and they decide to look for a lady, and they bring this lady to them, and money is going to exchange hands. It is an agreement. Now, you cannot claim this money back if the good lady that you looked for, who is being married to this other guy who is taking too long to marry, declines to marry this guy. You cannot claim your money because this kind of a contract is not recognized in law. You cannot be allowed to interfere with the sacrosanct institution of marriage. The other set of contracts that are void under common law are contracts in restraint of trade. What are contracts in restraint of trade? Contracts in restraint of trade are those contracts that are entered by people in the commercial environment, placing some sort of restraint. For example, you have sold your business. There's been some kind of merger, and the bigger entity, the bigger undertaking that is buying out this smaller company, inserts a clause in the contract of sale of this business that you will not engage in this kind of business within this geographical region for like 20 years. Yeah, that contract is a contract in restraint of trade. An employer inserts a clause in a contract of employment telling you that you will not be employed by our competitor in a period of 20 years. This employer has restrained you from entering employment or being employed by their competitor. And remember, the essence of having such restraints is to protect business, because you have known some secrets under your current employer. And if you were to terminate this contract of employment and you be employed by the competitor, you are likely to disclose these secrets to the competitor, and that is some sort of a restraint, that is some sort of competitive advantage you're giving to this competitor. So that the law provides that it is only when such kind of a restraint is unreasonable that it will not be allowed in law. But a restraint that is unreasonable is void. That kind of a contract is void. So that is what we are saying under contracts that are void under common law. Now, this discussion was meant to be very brief, because I also want to take you through discharge of contracts, because we are not fortunate to meet in class to discuss this topic. What do we mean by discharge of contracts? Discharge of contracts occurred when parties to a contract wash their hands in the contract. They no longer have obligations in the contract. A discharge of a contract will occur in several ways. When, for example, the contract is terminated by either party, the parties are discharged from their responsibilities in that contract. When the contract has been fully performed, we say that it has been discharged. The parties have discharged their obligations, their responsibilities under that contract. We also have contracts being discharged when they have been frustrated, for example. The doctrine of frustration occurs when a contravening event, something beyond the control of the parties to the contract, happens. For example, we now have COVID-19. There are so many contracts that are going to be frustrated because we are not having movements from country to country. Flights have been discontinued until further notice. Imagine you had a contract with a Chinese international, for example, to transport goods from Beijing to Kenya. And now flights have been discontinued. That contract is frustrated because of this COVID-19, so that it can no longer be performed. That contract is terminated, not from the will of the parties, but because of something that is beyond their control. A contract can also be discharged by breach. When one of the parties breaches the obligations under the contract, the other party is discharged because they are going to initiate a claim in court. They are going to claim for damages. They are going to claim for specific performance, for example, and therefore that contract will stand discharged. It will not be performed after that because the parties have now terminated the contract under breach. A contract can also be discharged as a result of operation of the law. Let's take the example of the law that was passed by the Kenyan government prohibiting the use of plastic paper bags. And we assume that you had a contract with someone, let's say a Ugandan national, to import, let's say, bananas, because Ugandans are known for producing many bananas. And the agreement was that they are going to pack those bananas in plastic paper bags. And now the Kenyan government passed a law prohibiting the use of plastic paper bags. And that person will no longer package those bananas in those plastic paper bags because the agreement was that they package those bananas in those plastic paper bags. But now the law has been passed with the effect of prohibiting the use of plastic paper bags. Let us also assume that the contract was for the import of those plastic paper bags that have already been outlawed by the Kenyan government. This contract will not continue because the law has been passed. There is a law in place that provides that plastic paper bags are not supposed to be used within the jurisdiction of Kenya. So such kind of a contract will be discharged by the operation of the law. So that is what we are saying. If we were in class, we would have had a concrete discussion about these things. I remember how you guys usually contribute in my discussions. I remember how the kind of healthy discussion that we usually have in class, you should have been able to get your 10 marks for participation. But now, this is our forum that we're going to use to discuss these things. There's also one last topic that we should have had an opportunity to discuss in class if we were able to do that. The topic of remedies. Remedies is a very important topic in the law of contracts. Remember, all along we've been saying that a breach of a contract gives rise to a right on the other party whose rights have been breached, whose rights have been violated, to sue the other party for damages and other remedies that are available under the law of contract. We have all along been mentioning repudiation of the contract being declared void. We have all along been discussing about damages. Now, this is the topic where we discuss remedies. And the remedies have to be directly related to the breach, the doctrine of causation, so that the breach of the contract by the other party has to have directly harmed this party, and the innocent party has now an opportunity to sue the person who has breached the contract in the court of law. Now, the court of law will look at the breach itself. Is it a material breach of the contract? Or is it a condition of the contract that has been breached? Is it a warranty? Is it an innominate term? Remember we said that when a condition is breached, it leads to the contract being declared void because you are having a material term of a contract, a term that is at the heart, that is at the crux of the contract itself being breached. Is it a warranty? Because a breach of warranties will give rise to suing the other party for damages. And now there are two types of remedies that are available for a party whose rights have been breached by the other party. Now, there are damages, there are common law remedies, and there are equitable remedies. So we have common law remedies. On the other hand, we have equitable remedies. Please take note of this. We have common law remedies and we have equitable remedies. Under common law remedies, we have damages only. You are you are seeking to claim damages. You are seeking to claim monetary remedies. In this court, you're seeking compensation. And there are two classes of damages that the court can grant the party whose rights have been breached in a contract. We have nominal damages. Nominal damages arise where the innocent party's rights have been breached, yes, but it is not a material breach. There is no injury that has resulted from this violation of the rights, so that the court will only grant a nominal value of the remedies, so that what the court is going to grant you is only for the breach and not, it is not compensating you for any injury, because you have not incurred any loss, any injury. It is only that your rights have been violated, but there's no injury. The court cannot see any injury. Could be because you have not pleaded your case on a balance of probabilities, and the court cannot see any injury, any damage that you have suffered. Remember the difference between damages and damage. A damage is the injury that you suffer. Damages are what you get as compensation. There's also substantial damages. Substantial damages arise where your rights have been violated and you have also incurred injury. So the court will award you damages for the breach of your rights. Your rights have been violated. It will also compensate you for this injury that you have suffered. For example, you were to transport goods from overseas, yeah, and then when the ship is along the high seas, this other party terminates the contract. You have incurred loss while entering this contract of affreightment with the carriers. You have already paid the carriers to transport these goods. But now, even before you reach the destination, this other guy terminates the contract. How can they do that? You are going to suffer injury, and then you have to ask the court to award you these substantial damages because you have actually suffered injury. This injury, remember, we are talking about the law of contract and not the law of tort. This injury does not have to be injury on your person, on your body. It is injury money-wise. You have undergone substantial loss, and that is what you are trying to tell the court. Now, the other kind of remedies is common law remedies, equitable remedies, and these equitable remedies are at the discretion of the court. You actually have to plead your case, and the court will then look at what remedies are available, and equitable remedies are only going to be awarded where common law remedies, and that is damages, are not sufficient. There are certain injuries that a person can suffer, and monetary award is not sufficient. Yeah, you have suffered so much loss, so much injury that money alone cannot actually compensate you. Yeah, your business has been affected, has been largely affected. Yeah, your business has suffered because of this breach of the terms by the other party. The court has to look at other remedies to add to these damages that is going to be awarded to you. And that means that the court is look at several remedies, several equitable remedies that are available. And one of those is specific performance. Specific performance is a remedy that actually compels the other party to perform their obligations under the contract. Remember, there are those obligations that you set out in this contract. Yeah, you said that party A will do ABCD and party B will do CDF, and that is what you are asking the court to do. You are telling the court, please compel party A to perform what we agreed that he performs. Yeah, if you had agreed, if it is a contract between a buyer and a seller, and you agreed that it is a seller who is going to deliver the goods, you read section 28 and 29 of the Sale of Goods Act, Cap 31, and it provides that it is a duty of the seller to deliver the goods. Now, what we mean by delivery is a question for another day, is a question that we can discuss another day during our discussion on our e-learning portal. Now, you are telling the court the seller did not deliver the goods. Compel the seller to deliver the goods to my business premises. That is what you're telling the court to do. It is not an award. Yeah? It is a duty. You are compelling this other party to perform a certain duty. Now, the other equitable remedy is injunctions. Now, for injunctions, you are telling the court to either temporarily stop this other party from doing whatever they are doing, or permanently do that. And there are several types of injunctions that you can ask from the court. There's a temporary injunction. In a temporary injunction, you are telling the court to stop this party from doing whatever they are doing, because if they continue doing that and the case is still ongoing, by the end of the delivery of the judgment, you will have suffered irreparable damage. Yeah? This damage that you'll have suffered will be irreversible and irreparable. So that you're telling the court, please temporarily stop pending the hearing and determination of this case. Please let him stop doing whatever they are doing, because if they continue doing it, I will suffer irreparable loss. So there's also a permanent injunction, so that you are telling the court to permanently stop this other party from doing whatever they are doing, and that is what we would have discussed on injunctions. They also contra meruit, where you can also ask the court to compensate you, to allow to compel the other party to compensate you for the fraction of the work that you have done. Yeah? In this case, you may not have performed the contract fully. You only performed a fraction of what you had agreed to perform. And therefore, you're telling the court, let me be compensated for the fraction of work that I've done. That is contra meruit. Now, we would have discussed a lot more in this discussion, but now we'll continue this discussion in the e-learning portal. Remember, the university have designed a very interactive e-learning portal that we can continue interacting. Remember, all these materials that I've briefly discussed to you will be provided in your emails and also in the e-learning portal. Please let us meet there and continue with these discussions, and please keep safe. Yeah, you keep distance. Please sanitize your hands. Yeah, please keep safe, because the virus is spreading very fast, and you have an obligation to ensure that we stop the spread of this virus. Please, ladies and gentlemen, let us keep safe. Let us stay at home. Let us break this chain. Let us flatten the curve of transmission, and we are going to conquer this virus. Thank you very much.
These televised lectures supplement our robust online learning going on our MKU online platform. You can view more on our televised lectures via our online platform. We are in a digital era, and Mount Kenya University knows this. The following are the steps to follow so as to complete your online application. Download the application form from the website www.mku.ac.ke. Attach copies of your academic certificates and ID. Pay the application fees via M-Pesa pay bill number 270988. Your ID is the account number. 2,000 shillings is the charge for a postgraduate. You can also deposit in the bank accounts provided on the website. Then email all the above to apply@mku.ac.ke.
Well, a very good afternoon to you. I hope your day is coming up well. You're right on time for News Deck with me, Linda Alela. It's important that you interact with us, and of course, the Twitter handle is at TV47, at TV47 also on Facebook. Let's get to hear what you have to say. But then again, we are here to update you on what is happening in the world of news. And we start off, or we kick off with matters politics, as the Jubilee Party Disciplinary Committee is hearing the case of nominated Senators Millicent Omanga and Victor Prengai. Before the committee, Senator Millicent, of course, was cornered over her earlier remarks, which were deemed inappropriate. However, she says she was defending the party, adding her loyalty to the party remains. And now we cross over there to the Jubilee House, and we get to see the grilling of Senator Prengai, which is ongoing.
How many people will be involved? Forbid that that kind of thing happens. We pray that doesn't happen. As you sit here this morning, are you apologetic? Let me ask you a direct question.
Yes, Mr. Chairman. If there is anything that I've done that may have maybe hurt or do anything, especially to my party leader and the leadership of my party, I sincerely apologize. And
your party leader might be watching you now. If he has the time to do so, what do you want to tell him now?
Yes, that is what I'm saying. Yes. If there is anything that I've done that is contrary to the wishes of the party, I sincerely apologize, and I will remain loyal to the party going forward.
Mr. Mboga, do you have any question?
Senator, as a politician, are you likely to be believed if you told anybody that your regret is in the heart, so to say?
Yes,
that's how politicians communicate.
I have said it, Mr. Chairman, from my heart, and that is my conscience, and I regret that I didn't attend that meeting.
Are you opposed to the resolutions of the meeting held on that day?
No, I am not.
As you are seated there, if that list is brought for your signature, are you able or likely to append your signature?
I don't know, because, you know, I was not in State House.
No, I'm only saying, my question maybe you have not understood. You know, when you were being served, you refused to acknowledge. When you were being served with the notice to show cause. When the Honorable Senator brought the list, you equally declined and gave those reasons that you want to be in the presence of the party leader for you to affirm to what was or what the contents were. And you are here, a politician from the minority, who should be even more clear to us, making it very difficult for us to really know where you stand. We have difficulty appreciating your defense. You could have made it very easy for us, but we have difficulty appreciating how you are doing it, because as a politician, you should have said, my apology to the whip is on the way, or has already been received by the whip. So that would be what we are saying. We should not really push you to tell us you are representative. As a politician.
You know what the member is telling you?
Yes, Chairman.
By your conduct, by the way you're answering your questions, and there's no power in your village, maybe that if this on radio they are listening, you want to take away the seat for the Ogiek.
No, Mr. Chairman.
Yes, that's what you are being told. You want to deny the Ogiek their seat in Senate?
No, Mr. Chairman.
I can't help you more than that.
What I'm saying is, Mr. Chairman, is that if, you know, I said earlier that Senator brought a list.
Forget about that.
Call them the interesting matters of politics. We'll have our reporter, senior reporter, and indeed matters political affairs reporter, that is Liz Mutuku, who's on ground. She'll be preparing a much more comprehensive report in regards to the grilling that is ongoing. But that aside, to some bit of matters education. And Kenya National Union of Teachers, in conjunction with University Academic Staff Union, KMPDU, and FAWE Kenya have released a joint report on the effects of COVID-19 on teaching, learning, and the necessary mitigation measures. They have recommended that national safety of teachers, pupils, students, and all the other education workers. Here is more on the report, as examinations will be pushed to the first quarter of 2021. Speaking earlier today, Secretary General Nat Wilson Sossion has said that prior to the reopening of schools, the government should have a thorough meeting with all the education stakeholders to ascertain this. Our reporter also, Andren Kilemi, is on ground gathering that report. We'll also get a comprehensive report on the same later on our subsequent bulletin, but not to exit before we take a look at what is playing out in regards to the take of the people on ground. And we spoke to the residents of Migori, and well, first of all, we'll listen into what, of course, Sossion had to say, and then we'll cross over later on to get the take of the people on ground.
Number one is that we've carried out the methodology. A desk study analysis of literature and other secondary data was undertaken between April and May 2020 on effects of COVID-19 pandemic on education, on e-learning and remote learning. And we wish to state, e-learning cannot work. It poses a lot of inequity. One biggest risk in COVID-19 is inequality in access of education. Thousands and thousands of children cannot access e-learning. Even those who access cannot interact with teachers. And any learning that does not provide two-way process of interaction with the teacher is not learning. Number two, we also carried out a rapid assessment by use of semi-structured survey questionnaires administered to the union's national infrastructure, whereupon responses were received from a representative sample of 33 branches out of total 110 branches of NAT, where a lot of data responses and suggestions were forwarded. 3, further quick surveys using online questionnaire to capture data from teachers from the ECD, primary and secondary, sampled from the branches, NAT branch executive secretaries, and selected branch executive committees and WASU national officers. And 4, analysis by WASU Technical Working Committee on COVID-19 and its ramification on education sector. And we really would like to sincerely thank WASU, because this is a union that is rich with all manner of experts. If you talk of researchers, they are there. If you talk of medics, they are there, and you'll see their recommendations in this book. Number 5, expert analysis by Dr. Florentius Koech-led team of doctors and health experts of Moi University on coronavirus and its implications of reopening of learning institutions. Number 6, an overview and scan of the global perspective on schools reopening from unions in the diaspora. We are working with the unions in diaspora and very closely with Education International. And we are engaged in various webinars, Zoom, and all other manner of conferences to share experiences. And the US teachers are working very closely with the doctors in the US. And one common phenomenon all over the world is that government seems to be in a hurry to force children back to school. But we're saying lives of teachers and children and workers are more important. And we wish to state that here in Kenya, and as per our data, majority of our teachers are an aging population. Most of them are age 45 years and over. So they are more at risk, very much at risk when it comes to COVID-19. Those over 55 years or 50 years and over should not even step anywhere near schools because of COVID-19. So if that be the case, then who will be teaching? Those are scientific facts. Number 7, analysis of the UNESCO-UNICEF framework for reopening of schools. That is one of our major reference material. And number 8, analysis of the guidelines recommended by the International Teachers Task Force on schools reopening. And number 9, rapid response and analysis by the Kenya Human Rights Commission and Human Rights Network on access to basic services in non-formal settlements and rural poor communities. And number 10, executive analysis and validation by FAWE Kenya and Elimu to Itakayo policy teams of the COVID-19 report. And so, as I've outlined, you can see this is a very extensive work that has been consolidated. And we urge the government to address itself fully to this report. Finally, let me read the submission letter to the National COVID-19 Response Emergency Team based at the Office of the President, Nairobi. Dated this day, the 27th May 2020, by the 5 organizations that have worked very closely, KMPDU, FAWE, pamoja tutetee haki, that is Kenya Human Rights Commission,
and TV47 spoke to residents of Migori County in regards to the reopening of schools, so we get to hear their take. Listen in.
We as parents of Migori County, we will not accept students go back to school unless we are assured of their security, unless we are assured of their safety. Because some of these schools have been used as quarantine centers, and we don't know how long this epidemic takes before it dies off. So it will have to be sprayed, it will have to be prepared, and security made available, so that when they go back there, they are safe.
I advise that the government put measures in our various schools that will really assist our pupils. Especially in our boarding facilities. We realize that, like in Migori County, we still have several schools that doesn't even have water points. And with this pandemic, this coronavirus issue, you know, water is really essential for our hand washing and also taking care of our cleanliness on daily basis.
If they report back to learn, that they will be safe together with the teachers who are handling them. And therefore, our thought is that we need to save lives as we prepare them for examinations, which will come when it is declared by the Ministry of Education.
All right. Now, even after the government allowed truck drivers to cross the Malaba border after meeting requirements, drivers are still stranded at the border. Queues at the border post that stretch more than 50 kilometers. And now let's cross over to Malaba border. Our reporter Mike Agungo updates us more.
Yes, indeed, I can get you loud and clear right here from Malaba border. And as you can see, after the government yesterday announced normalcy here in Malaba, truck drivers have started moving one by one. It just started yesterday after those trucks that have been parking right there inside the station itself at the border point. The truck drivers that were there got tested for COVID-19. According to them, whom I have talked to this morning, they say that they were tested for COVID-19 and yet they will stay or wait for 48 hours to know their fate or to know their results, and that is when they will be allowed to get into Ugandan side. And they say that nothing yet has changed even after they had striked to cause all these lines that has gone up to Bungoma, up to Bukembe, up to Webuye side. These drivers are now complaining of time that has been taken to test this driver or to test them at the border itself. Now they say that there is no difference up to now, even after the government allowed them to get in or to be tested for COVID-19 or to get in to Ugandan side. So they are waiting for 48 hours. Those, as you can see, these drivers passing by, even if my camera person can pan on, they are moving slowly by slowly, as you can see. And once they get there, they will get tested. They're going to park these trucks inside the border station, that is Malaba border point. They will park these trucks there and get tested for COVID-19. And that is where they will be waiting for 48 hours. They will wait for 48 hours to know their fate and to know their results. Then that is when they will be allowed to get into Ugandan side. Remember, these drivers are getting tested in Mombasa. They get tested and they wait for 48 hours and then they got released to come to this side. Then when they come to this side, when they get this side, then they will be tested again and wait for another 48 hours. Now, they claim that there is no difference for all these line, because waiting for 48 hours still causes all these line up to Webuye. So there is no difference amid government allowing them to get in or allowing the officers to get them tested for COVID-19. So we have a meeting today with delegates. Delegates are meeting, that is to know or to solve the issue or to know whether or what time will be taken for them to be allowed to get in. So we shall be bringing you in our subsequent bulletin all that's happening in this border point and everything that's happening here and everything that shall maybe arise. We shall be telling you right here from Malaba. Back to studio. My name is Mike Kagwanga.
All right, thank you so much, Mike Kagungu, for that comprehensive report all the way from Malaba. Now let's cross over to a different story on matters rains. And the country will continue to experience heavy rains up to the end of June, according to experts at the Meteorological Department of Kenya. In a press briefing, Devolution CS says that the government will help affected families in the 33 counties affected by floods and landslides to rebuild their lives as the rains and flood waters subside. Let's listen in.
Had 808,000 Kenyans affected by the ongoing heavy rains, the floods, the landslides, and the mudslides. As of midnight last night, the total number of lives lost have risen from 256 to 285. And also the number of people affected has risen to 810,655. This is just a part of the effects of these heavy rains that have been ongoing, but we also have acreage in terms of crop loss in many parts of the country that our colleagues in agriculture will be confirming by next week. As the rains subside, we will be able to establish the exact acreage in terms of crop loss that we have suffered, in terms of the irrigation land and infrastructure that has been affected, and we will be able to give you a more comprehensive report next week. But also, we take this opportunity to thank our experts. The Meteorological Department has been of great help in terms of giving us very accurate information.
Well, exactly 18 minutes past the top of the hour. I think it's important that we take a breather. We'll be coming back with much more news, so don't you go anywhere. Welcome back to Newsdeck. Thank you so much for staying put. Now, a multi-agency investigation is being conducted to establish the source of poisonous food that was distributed to residents of Gikambura village in Kikuyu constituency Sunday evening. Now, the food was branded the same as care packages being distributed by the area member of parliament, Kimani Waishungwa, in conjunction with Deputy President William Ruto's foundation. Now, the two leaders have distanced themselves from food, which left at least 9-10 people receiving treatment in various hospitals in Kiambu County.
We said yesterday we carried samples. Some samples were taken to government chemists. Other samples were taken by our people in order for control, because we don't want any interference. So the tests are going on, and we'll be able to give, the tests will not come out quickly. I think in another two or so days, we'll be able to know what exactly the problem was. We are following the patients. I visited all the 19 patients yesterday. We are following them. They are progressing well. A lot of them had burns in the mouth and in the stomach and all of that, and they have been treated with antacids and others until we know what exactly this product would be. In the meantime, we are dispatching a new lot of food into that place. Tomorrow, I'll be giving out food in those places, because we want to make sure that people get the right food. And we insisted, anybody trying to give food, you have to follow the right channel. And the right channel is the one that we'll be following as we move on. So people should avoid, getting food from all over. Ask yourself questions, and then, then we can avoid a situation like happened yesterday.
And from Central and all the way to the Rift Valley, Uasin Gishu County Assembly has today approved a motion moved by Honorable Josephat Luwoi, Leader of Majority, on behalf of Honorable Gilbert Tenai, MCA Cheptritet Kipchamo, asking the county government of Uasin Gishu through the Department of Devolution and Public Administration to urgently prepare and submit to the County Assembly a public participation policy that will take into consideration prevention guidelines of COVID-19 pandemic, which include social distancing. Honorable Jenny To, nominated MCA, seconded the motion, saying the public participation is integral to the Constitution and bills passed without it risk being challenged in court. Members want other avenues like memorandum and video conferencing used, since only 15 people are allowed in a forum.
This corona has not suspended the Constitution, Mr. Speaker, sir. Neither has it suspended governments. The government still works. The Constitution is still in force. The other acts, the county government acts, the public finance management act, all these acts are still in place. That is why this motion has come here today, to allow us, ask the department concerned, to come out with a policy that will enable us go to our electorates physically, by virtual, or any other means that is possible, or by them doing memoranda, so that we can still make sure that we don't go against the Constitution in approving bills without a public participation, in approving any other thing like the budget without the public participation. Because timelines or deadlines are still there. Mr. Speaker, sir, this motion seeks the department concerned of devolution and public administration to come out with a policy that will guide us on how we can carry out the public participation, because the public participation is the core issue in devolution.
Mr. Speaker, sir, public participation, as this House is very aware, is a very significant factor in policy and bill making. Mr. Speaker, sir, it would be so wrong for us to push for policies or to push for bills without taking into account what the Constitution of the Republic of Kenya says about the participation of the people that we serve.
And still in Uasin Gishu, police in Eldoret have warned those flaunting government rules to prevent spread of coronavirus. Uasin Gishu Deputy Police Commander Zachias Nyeno says many people have started to disregard preventative guidelines, such as observing social distancing and wearing of masks.
tushapata watu kadhaa wenye watii amri yenye zimepeanwa, kama kufaa barakoa, wengine wafai, wengine wanatangamana pasipo na ile kitu inaitwa social distancing, ama kutokuwa na maanani sana mahali wameketi, na wengine wengi tushapeleka kotini, na wengine tushapeleka katika quarantine center, na siwezi nikakuwa na idadi kamili hapa sahizi, lakini naweza kuthibitisha kwamba kuna wengine wengi wenye watii amri, wenye washaonana na mkono wa sheria. Sheria hakuna mtu ashalegeza tangu rais wa nchi hii pamoja na waziri wa afya na kila hata county government of Uasin Gishu walipopeana hizo amri, hakuna mtu ashalegeza, na tulegezi kwa sababu janga la corona bado ni tisho kwa binadamu ama kwa wananchi wote, bila kujali umri ama kazi yenye mtu anafanya.
And across the continent now, the Democratic Republic of Congo calls for a domestic violence hotline in Kinshasa, citing that, of course, domestic violence has increased. And of course, as cases